The next case on your list, Your Worships, is Mr. Cavendish, who faces one allegation of driving with excess alcohol. Perhaps he might be seated while I explain the situation to you.
Please, if you'd like to sit down, Mr. Cavendish, please do so.
Mr. Cavendish is unrepresented for today's purposes, but he has handed in a letter from his solicitors, Internet Motoring Lawyers. They ask that no plea should be taken today, as they are unable to advise their client as to whether or not he has a defence in law, until they have seen all the necessary prosecution evidence, including the CCTV from the police station. They assume that the court will respect the defendant's human rights. They go on to say that if the court do not agree to an adjournment, then they have advised their client to enter a not guilty plea, and would hope that the court would explain that the defendant would still get full credit for a guilty plea if, after a full examination of the issues, the advice is that he has no defence to the charge.
Mr. Cavendish, would you please stand up? Mr. Cavendish, while there's no specific criticism of you personally, the court is satisfied that your solicitors would know that there are certain rules and procedures that govern the proceedings in these courts. One of those rules is that the court must take a plea at the first hearing, and that is what we intend to do today. Have you had an opportunity to give instructions to your solicitors or take any further advice from them?
Not specifically, no.
Well, as I've already said, the court must take a plea at the very first hearing, and that's what we would like to do today. And we're going to ask our legal advisor to put the charge to you. Ms. Rydal, would you put the charge to the defendant, please?
Sir. Mr. Cavendish, you are charged that on the 11th of August 2011, you drove a BMW motor car, registration number CAV12, on the A1 southbound at Oldbury after consuming so much alcohol that the proportion of it in your breath exceeded the prescribed limit. Do you plead guilty or not guilty?
I don't wish to indicate a plea, and I think this is grossly unfair.
Mr. Cavendish, I've already said that we must take a plea at this hearing unless there are valid reasons. Now, the reasons given by your solicitors requesting an adjournment in this matter are not strong enough for us not to follow the normal procedures, and so we will take a plea today.
I want it noted that I am reluctantly entering a plea of not guilty.
We do fully appreciate the difficulties you face not having your solicitors with you here in court today. What we're going to do now is we're going to hear from the prosecution, who will tell us about the facts of the case. Then we'll ask you some further questions which will help us to complete, with your assistance, what is called the case management form. So whilst we hear from the prosecutor, if you'd like to sit down, please feel free to do so. Thank you. Mr. Barker, what is the prosecution's case?
It couldn't be more straightforward, Your Worships. About 1:30 a.m. on the 11th of August, a marked police car was overtaken by the defendant's vehicle. The officers in that car would say that it was travelling in excess of the 70-mile-per-hour speed limit, and also that it was weaving between two lanes as they followed it. They caused the car to stop using their flashing lights, and Police Constable Mowbray went to the driver's side of the vehicle. When the door opened and the defendant got out, he staggered to such an extent that the officer had to help him to his feet. The defendant smelt of alcohol and his speech was slurred. He was asked to provide a specimen of breath at the roadside, and he did so. The reading recorded was 95. The defendant was arrested for driving with excess alcohol and immediately said to Constable Mowbray, "What a terrible mess. I've had some shocking news earlier today, and I'm afraid I have rather drowned my sorrows. I couldn't get a taxi and should never have driven." This remark was also heard by the other officer. The defendant was arrested and he was taken to Oldbury Police Station, where he provided 2 specimens of breath for analysis, the lower reading of which was 91, and that was about 2 a.m. On the MGDDA form, which, as your worships will know, is the document used to document the procedures, he was noted as being fully compliant throughout. At 2:20 a.m, the defendant was charged with the offence with which he appears before you today. Subject to anything that Mr. Cavendish or his lawyers would wish to say, the Crown would propose to call the 2 police officers to corroborate the significant statement and also to deal with the procedure at the police station.
Well, thank you very much, Mr. Barker, for outlining the facts. Mr. Cavendish, would you stand up again, please? Could you tell us why you think you are not guilty of this particular offence?
I have no idea, really. I contacted the solicitors on the internet, as their webpage said they would move heaven and earth to find a defence, and that a lot of these cases get thrown out on a technicality.
So, Mr. Cavendish, would you agree with the facts as outlined by the prosecution?
I would be hard-pressed to disagree, because I don't remember much about the incident. It would be fair to say that the previous day that I had some bad news, that the company, my company, had lost a multi-million-pound project, and that meant the viability of the company was in jeopardy.
So would you agree that you were driving that night and that you had drunk alcohol?
I suppose so, yes.
Can you think of anything that happened at the police station which might give you cause for concern, or did any of the police officers act inappropriately?
From what I do recall, I was treated very courteously by everyone concerned.
Can I make aware of what is called credit for an early guilty plea? What this means is that up to 1/3 can be deducted from any sentence imposed if a plea is entered at an early stage. The amount deducted will depend on how early that guilty plea is entered. If, however, you plead not guilty and are convicted after a trial, you will not receive any credit and the full sentence will be imposed. Can I now also refer to the fact that the expenses, that is, the costs that might be awarded against you, may well be considerably higher if you plead not guilty and the matter goes to a trial. What that means is, if you do not plead guilty at an early opportunity and the matter goes to trial, then costs of up to £4,000 can be awarded against you for the prosecution. However, it is also noted that if you actually plead guilty at an early stage, those costs can be less than £100. Do you understand that?
I do.
Finally, I need to tell you that unless you qualify for legal aid, then you will have to pay your own costs. And it may well be that in cases such as this, those costs might not be insignificant. Do you understand that?
Yeah.
What we're going to do now is we're going to put the matter back for a short period of time to give you an opportunity to reconsider your position. We'll also allow you, if you wish to do so, to speak to your solicitors and to take further advice from them. Do you understand that, Mr. Cavendish?
Yeah.
Thank you.
Yes, I'd like to do that.
Okay. Thank you, Mr. Cavendish. Have you had an opportunity to speak with your solicitors and take further advice?
Yes, sir, I have. And I wish to plead guilty to the matter. And I've been told by the solicitors to ask the court for full credit for an early guilty plea.
Very well, Mr. Cavendish. The matter will be put to you again and you will be given full credit for that early guilty plea. Thank you very much.
Thank you.